So you should be able to get your video on. Great, everybody is getting on. Professor Cohen, you should be able to turn on your audio and visual as well. Awesome. Okay, so I say we can get started. I will work with the other panelists to try to get them onto the Zoom, but don't want to waste any time, and you all can go ahead and get going. Professor Cohen, I will hop on about 10 minutes before the end of the panel just to lift up some audience questions. There's also going to be a poll that pops up in the middle. It's for CLE credit. You all can ignore it. It's just for people who need CLE credit. All right, but go ahead and get started.
Megan, thank you so much. Hello, everyone. I'm Amy Cohen, and I'll just go ahead and introduce everyone, beginning with RJ, and hope he joins us soon, and then I'll turn it over to our panelists. I'm really delighted. This is a special group of people that we have. I'm delighted to be able to moderate and introduce them. So RJ Thompson, who will join us soon, I'm sure, is a longtime human rights lawyer, organizer, and educator, as well as a certified personal trainer, vegetarian, go-go dancer, and performer in the adult film industry. He's currently the managing director of the Sex Workers Project, a leader in the national sex workers' rights movement. Noah Zatz is professor of law at UCLA, where he works on inequality in labor and social welfare policy, and is especially interested in people organized outside or at the boundaries of conventional labor markets. At UCLA, he's core faculty member in the Critical Race Studies program and the program in Public Interest Law and Policy. And finally, Andrea Armstrong is professor of law at Loyola University, New Orleans, and a leading national expert on prison and jail conditions. Her current grant-funded projects include examining the effects of incarceration on health service use in Louisiana, and supporting law schools who wish to collect death in custody data for their carceral facilities in their states. All right, oh, and welcome, we're all here. So just to kind of frame our hour together, our panelists today in their writing, in their organizing, in their policy work, all challenge a common distinction between labor and exchange that gets called work and is therefore understood and regulated as part of the market, and labor and exchange that gets called a crime or that happens within the confines of our racialized carceral system, or both. Our panel is about sex work and prison labor. So I'm going to begin by asking you each to just tell us briefly about the kind of work that you study and that you organize around. And if you could say a bit about the kinds of political sensibilities and demands that follow from how this work gets described in mainstream policy discourse, and more specifically from how it gets located in the market or in the carceral state. And if you each take maybe 3 to 5 minutes to kind of orient us to your work, and then I'll drill down more deeply. And Noah, let's start with you.
Okay, great. So first, I just wanted to thank the symposium organizers and you, Amy, for facilitating this session. It's really exciting to be part of an event structured around the questions of what gets recognized as work and who gets protected as workers. Those are the questions that have driven my whole career. I came to this topic through feminist theory and through the critique of the idea that the family and the economy are separate spheres. And so rather than simply focusing on women's inclusion and equality within the labor market, the argument goes structures of gender hierarchy historically include the privileging of market work itself. And that structure renders invisible as work what is sometimes called socially reproductive or caring labor that occurs in unpaid forms in families and communities. And it positions people, primarily women, who perform that work as dependent rather than productive. It also stigmatizes people who perform for pay work that is assigned ideologically to family life, which I think we can see in the criminalization of sex work. So this led me to become very interested in and opposed to, in the 1990s, welfare reforms that were structured around so-called work requirements. These denigrated low-income single mothers as lazy and unproductive when they cared for their own children, and instead pressed them toward the labor market. So I spent my first law school summer at the Urban Justice Center in New York City, RJ's shop, working on welfare rights and supporting welfare organizing. And what really struck me was how even after low-income women of color were pushed out of caregiving and into what the system itself called work, in workfare positions, cleaning parks and so forth, they still weren't recognized, respected, compensated, and allowed to organize as workers. The state said that they were not employees protected by labor and employment law. And the rationale was that employment is intrinsically a feature of contract in the labor market. In contrast, this work that they did was structured by the state institution of welfare and workforce development, and therefore was to be understood as part of a practice of assistance or rehabilitation. So there were two things that at a high level of abstraction tracked the non-recognition of non-market caregiving. One was the invocation of separate spheres to identify work with the labor market and then to treat other domains as non-economic in nature. And then second, the stabilizing and deploying of that distinction by mapping it onto broader hierarchies of racialized gender. So while litigating some of those workfare employment rights cases, I noticed relevant case law coming from prison labor cases about the employment rights of incarcerated workers. And when I later began researching that as an academic, I found separate spheres ideology running throughout prison labor jurisprudence. So for instance, a leading Seventh Circuit opinion held that incarcerated workers could not be protected as employees because, quote, prisoners are essentially taken out of the national economy, end quote, and instead they worked in the, quote, separate world of the prison, end quote. So that idea of separateness is very powerful, as is the invisibility of the carceral state as an economic institution generally. And the racial politics of that are particularly obvious given the well-known anti-Blackness and broader racial targeting of the criminal legal system. So then my most recent work attempts to challenge this idea of separateness and how it obscures how the carceral state can, does, and might increasingly manufacture racialized labor subordination and exploitation. And that's this project under the heading of Get to Work or Go to Jail. And here, rather than people who are currently incarcerated, my focus is on those who are nominally free, but are threatened with incarceration if they don't work or don't work enough or in the right ways. And this is, again, a regime of work requirements, but now it's one where the state gets its leverage not from threatening to withdraw financial support, as in welfare, but instead threatening to arrest and incarcerate. And some of those threats come directly from the criminal legal system, such as through the work requirements that are typical of probation, parole, and diversion rules. And others are mediated by fines and fees or child support debt that can be enforced through incarceration, linking up to all of the recent energy around so-called new debtors prisons. And those demands for payment are often translated legally and institutionally into demands for work, so that people who cannot pay may still be incarcerated if they are deemed to have failed to seek or accept employment. The potential for abuse there is pretty obvious. Employers can now threaten workers with incarceration, not just poverty if they lose their jobs. And that's sort of similar to how employers exert power over criminalized workers who are vulnerable to being reported to police or to immigration authorities. And so in that vein, I just want to give a brief shout out to an active organizing campaign by Laborers Fight Back in New York City, which is targeting what they refer to as body shops in the construction industry. That's just one example. So then finally, the very fact that work is done pursuant to these mandates from the criminal legal system can then be used to strip these most vulnerable workers of employment protections. So when mandatory work is performed through an institutionalized program, we see the same arguments from workfare and from prison labor that it's outside the market and therefore it's not really employment. Instead, it's part of punishment or it's part of reentry or something like that. And there's also some 13th Amendment case law that permits involuntary servitude when it enforces some kind of public obligation, whether it's military service or family support, kind of completely aside from the famous textual exception to the amendment. So I'll stop there. That was just an attempt to kind of sort of show an arc through different kinds of marginalized work and what they have in common in some ways. And then I'll look forward to elaborating. Thanks again. I'm so excited to be here.
Excellent. Thank you. Thank you. Andrea, do you want to jump in?
Yeah, and you know, one, I'm really glad to be here, honored to be asked to speak on this issue, and thanks as well to Noah for kind of really providing the foundation for us to engage in. So, you know, my work in this area, thinking about prisons and the intersection between the conditions of incarceration and the Constitution, I've been doing this, I don't know, 15 years I've been thinking about this question, right? And it all started, in fact, because I was in Angola and I was meeting with someone, and he just looked at me and he said, well, why do they get to make me a slave again? And I was like, ah, right. You know, I don't have the answer to that question, but let me go see. Right. And so, and that was the prompt that led me to thinking about the 13th Amendment. And when we think about incarcerated labor, we cannot even have that conversation without understanding how secret prisons and jails are, that we as the general public very often have no idea what it is like to be incarcerated. And we have an idea of what we think it's like, you know, when we see that in the TV and the films, but this idea that the person who has been convicted and is serving a sentence, you know, once they're inside, what they actually did to get inside is actually irrelevant and not part of, you know, it might be a part of their classification record or their housing assignment, but it makes no difference in terms of what job they might be forced to do, right? And even further, their sentence is for a particular set of years, but it's not at a particular facility. And so prisons and jails have very different ways of forcing people to work and the types of labor that they expect them to do. And so, you know, when we think about incarcerated labor, and I think going back to your question, Amy, around, well, what does that mean for political sensibilities, right? And the ways in which we talk about this in the general public, I think first we have to say is we actually don't know that much about how it works inside, and that is by design and not a defect in the system, right? So up until 2002, there was an annual survey on what were the work assignments that were given inside. And that survey, which was done, you know, by an academic kind of center with some grant funding, provided an important service because our prisons and jails don't tell us, general public, taxpayers, community, families of people who are incarcerated, they don't tell us what jobs are inside, what they're paid, or under what conditions. And so I think we have to start with that first. The second point that I would also kind of building off of comments that Amy and Noah, you both talked about in terms of race. Race is a huge part of how we think about who is incarcerated. And this idea that idle hands are the devil's hands, right, which is often used to justify forced labor inside, has roots, has deeply racialized roots in this country, and the way that we talked about people who were African Americans and enslaved. And also, to be quite honest, when we think about slavery, we think about it in terms of the US chattel system, particularly around African Americans. But as even Supreme Court cases have recognized and acknowledged the history that we have had versions of different types of slavery, including Mexican Americans in the Southwest, Chinese Americans in the West. And so thinking about all of the justifications for subordinating that labor historically, we still see reflected today in everyday discussions about what incarcerated labor, why it's justified, and what it should be doing. And so I think that context is really important in thinking about it. And a little bit later, hopefully I can share with you some of my research and thoughts about incarcerated labor as it operates today. Thank you.
Thank you. And RJ.
Yes.
Welcome.
Hi, everybody. It's so good to be here as well. It's a rare opportunity that I get to speak at these intersections. I myself am a former public defender and death penalty abolition advocate, doing sex worker rights work now, but the intersection of these issues are so profound and so rarely discussed. So thank you for this venue to do so. So at the Sex Workers Project of the Urban Justice Center, we have been providing one of the few organizations in the country to provide direct legal services specifically to both sex workers and survivors of human trafficking for 20 years now. And we sit at the intersection of those two often separated movements. I say separated, not separate, because they're artificially separated in some ways, purposefully, as well as conflated. But it's important to note that we we fight human trafficking every day, as well as for the human rights of sex workers. We also engage in policy advocacy work and education nationwide, and are currently engaged in decriminalization efforts in Oregon, New York, Louisiana, and supporting colleague organizations that are doing that work in other states and regions too. So at this very moment, it's sort of a tipping point where there is some sort of decriminalization, either study bill or actual decrim repeal bill in every region of this country, in about a dozen states at this point. And we are, to your framing question, Amy, the discourse out there is terrible around this issue. It is terrible in the media, it's terrible among elected officials, and the mischaracterization and misunderstandings around the sex trades is so deep across society, so deep, the stigmatization is so deep, that we're constantly having to fight that stigma around what sex work is and who we are as sex workers. I'm a sex worker myself, as well as an attorney for 20 years now. At the same time that we fight for policy change, at the same time that we try to make inroads with other worker rights movements and other movements to end mass incarceration and to transform or abolish the criminal punishment system. So a couple of the things that the discourse raises up in terms of demands are that we demand an end to the rescue and victim narratives that surround the issue of sex workers. Generally, there are two extreme narratives that surface. One is a constant victim narrative that is often conflating sex work with human trafficking. And the other is what we call this happy hooker narrative, which is often a narrative around cisgender white women who are doing sex work from a place of sexual liberation and complete choice and autonomy. And those two extreme narratives fail to represent the nuance and the complicatedness of human experience generally, and human experience within the sex trade certainly. So at SWP, we talk about a spectrum of choice, circumstance, and coercion. And we don't think about those things as three boxes to put people in. Our clients for 20 years have shown us time and time again, as well as those of us with direct lived experience in the organization, in the sex trades, that is a spectrum in a very literal sense. It is not a box or categorization system. So people might do voluntary sex work at one point in their life, and they might have a trafficking experience at another point in their life. Because of the way US law is set up, very problematically, sorry, a CLA credit thing. Just, I'm trying to ignore that. Very problematically in US law, because it distinguishes sex trafficking from labor trafficking, which in human rights law and globally are not necessarily distinguished. Sex trafficking is one of the many forms of labor trafficking, because if sex work is work, then certainly sex trafficking is labor trafficking. This dichotomy in the law makes it so that people can and often are charged as traffickers. For example, if you are a 20-year-old sex worker helping your friend with safety planning, housing, transportation to gigs, and they might be, 17, you can and are often charged as a trafficker. So the conflation even permeates how the law operates and who is arrested and for what. Not to mention the police raids that are part and parcel of this rescue industry. And the rescue industry has some strange bedfellows, from the evangelical right to second wave feminist groups. And this might be the only thing they agree on, but they certainly agree that sex work is bad, that it is always oppressive for women and girls. Men and boys, by the way, do not fit into their narrative because we complicate it too much, and they actually can't answer where we fit in their narrative. So we just don't exist, and they tell us that to our face. So, these strange bedfellows that are purposefully confusing and conflating the issue of human trafficking with sex work to confuse the public, to confuse legislators, to try to push this so-called Nordic or equality model, which criminalizes our customers and managers, the majority of which, that's sort of seen as this liberal compromise issue, unfortunately, right now in the US, but it's not a compromise position because it criminalizes Black and brown men in particular, where that Nordic model has been implemented. Many sex workers work within intra-community conditions. It's not this sort of pretty woman narrative of sex work. And so if you stop criminalizing workers, but you continue or exacerbate criminalization of clients and customers, not only is it like saying you can operate a business legally, but have no client base and directly harms the financial life of sex workers, some of whom are in survival mode, but it also, like every other criminal punishment policy solution in this country, is racist and classist, and the people who will bear the burden of it are Black and brown men, migrants, and poor people. So, we use 4 frames at the Sex Workers Project in all of our work. We try to intersect a human rights frame, anti-oppression, trauma-informed, and harm reduction approach. And some of the intersections that this issue inherently cuts across are sexual freedom or sexual liberation, bodily autonomy and reproductive justice, worker rights, migrant rights, racial justice, and gender justice. So for me, as a person who has an intersectional identity and cares about many human rights issues, this issue is really profoundly important to me because it inherently embodies the intersections of all of these other labor and social justice issues. The last thing I'll say in the way of introduction is that, I really, in terms of the conflation around trafficking, these advocates who say that sex work needs to be abolished or we need to end the demand to curb trafficking, I've never heard them say that we should abolish or end the demand for farm labor, domestic labor, restaurant labor, construction labor, or any other labor sector. And the reason is because their anti-trafficking agenda is really an anti-sex work agenda that they're absolutely disingenuous about. It has roots also in this second wave feminism I alluded to. Often these same groups have been historically extremely and sometimes violently transphobic. We say serfs and turfs, these anti-sex work and anti-trans feminists. I don't think that they deserve to be called feminists personally, but they have this lineage, this history of racist, transphobic exclusion, and continues into their fight against sex work under the guise of anti-trafficking. And I really hope that this panel can also be a call in to other labor movements, worker rights movements, to join us, to show up for sex workers, to start walking the walk rather than just talking that talk. Because while we've seen people adopt the tagline of sex work is work, I used to do restaurant worker rights as well. We've had really a very tough time getting allies in other worker rights movements. And I understand that, every movement is overburdened and every movement has its own issues, but to really show up in a way that puts themselves out for the decriminalization of sex work and for sex worker rights as worker rights. I hope that changes in the coming years because this is a very under-resourced movement and we need all the solidarity we can possibly get.
Awesome, thank you. So Andrea, maybe I'll circle back to you first. You described working on incarcerated labor for over 15 years now. And in your writing, you describe incarcerated labor as not only forced or involuntary, but also as uncompensated and unprotected. And in your scholarship, you take on constitutional, statutory, judicial interpretation to argue to protect labor in all forms. So we'd just love to hear more. Tell us a little bit about this work.
All right. So I did do a PowerPoint, even though it's like 5 minutes, but it's because there's so many things that I want to share and tell. And, part of this is about the transparency, right? So my work on this is really going right now beyond the 13th. There is some amazing and incredible energy right now, particularly, after Ava DuVernay's film, but also growing awareness. And there's even been bills filed to eliminate this exception from the text of the 13th Amendment which I've put up here on the screen. And what you're looking at there is a picture of, this was a picture from 2010 in Angola of the field line going to work, right? And when you think about what does it look like for primarily Black men to be doing row crops, plantation crops, cotton crops in the South at Angola, with the history of that, which is something I've written about in a prior paper, it sure feels, looks, and smells a lot like slavery, right? But what I didn't address in my prior scholarship is really thinking about beyond that, right? So thinking about, well, what does it mean then for involuntary servitude? And so my research has been moving towards thinking about incarcerated labor, and not just, when it looks and smells and feels like slavery, but when it looks and feels like involuntary servitude, and really interrogating that idea. And for me, it comes down to these 4 criteria that I'll just briefly talk about, right? So I think of incarcerated labor as involuntary, as uncompensated, as unprotected, and also unrelated to the reentry or rehabilitative goals that we set for our prison system. And I'll briefly take these. The involuntary part of it, we really see through the 13th Amendment. And so I won't belabor that point too much in the little time that we have. But the uncompensated is worth understanding, right? So there is a lot of attention on the 13th Amendment, and rightfully so. But my argument is that in addition to the 13th Amendment, we actually use through legislative law, both federal and state, and we also through judicial interpretation of statutory laws, right? Through the interpretation, for example, of the Fair Labor Standards Act and what does it mean to be an employee, that we have a legal architecture that marginalizes and operationalizes involuntary servitude. And when we're thinking about how do we create change, we learn in our first years of law school that amending the Constitution is a pretty heavy and difficult proposition on purpose, right? But that amending, repealing laws, statutory laws passed by legislatures, whether it's at the state or the federal level, is a lot easier of a task. And so through this scholarship, hoping to expand the set of tools that are available for movements that are working on this area. So back to kind of my 4 kind of ideas of what typifies incarcerated labor. When we think about it in terms of uncompensated, that's not 100% accurate, right? Because in Louisiana and Angola, you can work in the field and you can make 2 cents an hour, right? Which means that you can make 8 cents, right? It is pennies on the dollar. And that is not a constitutional result. That is a statutory result. It is something that is set by our laws, which then give the power to our Secretary of the Department of Public Safety and Corrections to set the wage levels through our administrative code. And so I've provided a couple of examples here for you. But in addition, people who are incarcerated often have to choose what type of compensation, paltry or measly as it may be, they have to choose what they get. And so they're looking at, okay, well, am I going to make 2 cents an hour, right? Which is by and large the majority of the work that's provided at Angola, at least. Do I make 2 cents an hour, or do I continue to earn credit so that I can leave prison earlier and go back to my family, right? And forcing that choice, courts have said, well, yeah, it's a choice. And so it's up to you. But I think that that's a fundamental aspect, a statutory aspect of incarcerated labor that is under noticed and under discussed. To get a sense of what it really means, right? Because some folks will justify the compensation levels inside to say, well, room and board is being paid for by the state or by the taxpayers, right? And they don't really need to purchase anything. Well, that's not actually really true. Our prisons actually rely to a great deal on the money that of the people who are incarcerated, as well as the communities from which they come, right? So thinking about communications, thinking about video calls, phone calls, well, what does that mean in terms of an incarcerated person's wage Well, this is what it means, right? That a $3 copay to us on the outside, we may say, oh, well, it's $3. My copay is $20. But when you make 2 cents an hour, $3 is radically different. So that's a little bit about the uncompensated part. I want to also turn to how it's unprotected, right? And so when we think about labor that occurs, when I say it's unprotected, I mean that the law does not provide certain types of protections to the conditions in which people work, to the hours that they are expected to work, or in terms of the return that they would expect if they were to suffer an injury. Right. And so, I've listed a couple of ways in which our statutes, either by judicial interpretation or by our legislative bodies, have further excluded and shaped what it means to work inside of a prison. And this is critical, right? Because we actually use folks who are incarcerated in sometimes dangerous occupations, in dangerous jobs, right? So there was a lot of attention paid after the BP oil spill, for example, that we had people who were incarcerated cleaning the oil without proper worker gear and protection in terms of interacting with these noxious chemicals, right? That same person would not have been able to use the same remedies that the person working, a mile down the beach would have been able to use if they were injured as a result of the lack of protective gear, the lack of training that was provided to them. Last, I want to talk about how it's unrelated to reentry. This is a listing of every single type of job that is available either within prison enterprises or as a standard matter within prisons across Louisiana. And the ones in red are the ones which out of the gate are not related to reentry. When we think about who is incarcerated, and we know this because of the hyper incarceration of young Black men from urban areas, it is unlikely that they will find a future career in plantation row crops like sugarcane or cotton, right? And so we need to think about who are the people who are inside, and if rehabilitation is in fact, and I use that word in quotes because we often have a kind of skewed idea of what it means for a person to be rehabilitated, because we do a criminal act that doesn't define who we are or who we will be, I think, more importantly. But so this list kind of gives you a sense, but you should also know that there just simply aren't enough currently of the desirable jobs, the ones that are related to reentry, given the sizes of our incarcerated population, which is one of the primary justifications for the continued use of these penal plantations throughout the Delta region and throughout the South. And so these are kind of my typical features, or my take on the typical features of incarcerated labor. And I think really point us to what it means to think about incarcerated labor beyond the 13th Amendment, right? Because eliminating that conviction exception for the 13th Amendment doesn't necessarily mean that people will get paid, that they will get protected by the law as every other worker would be, or that they are being adequately trained to succeed for their lives after release. Thank you.
Amazing, thank you. Noah, some of your work follows really well on the ground that Andrea just laid out for us, because you're thinking about the relationship between incarcerated labor and then work that happens under the threat of incarceration, what you briefly described as worker jail. So say more, that follows well.
Sure. So let me sort of step back a little bit. The carceral state in general, I think, typically gets ignored when people talk about work inequality, unless they are already focused on the criminal legal system context, right? So, the standard narrative that we hear all the time is we live in an area of precarious work in which work and the market has been deregulated, the state has withdrawn, private capital is running amok, that sort of story, right? That's a story of a kind of shrinking state. And the irony of that is it's that story is happening alongside the sort of massive and brutal expansion of state violence through the criminal legal system and immigration system. So the big question is like, how do you think about those two things together? And when people do that, when people think about how the criminal legal system is an economic institution, typically, I think you see kind of two different moves. One is a kind of prison industrial complex move that focuses on prison labor and the exploitation of prison labor, right, linking up with all of the sorts of things that Andrea is talking about. But very often an emphasis on sort of forced labor that's very sort of separate from kind of regular work. So that's one move. And then the other move is to focus on the exclusion in the quote unquote sort of regular labor market of people who have criminal records, right? So that's been a major theme of work on reentry, a major theme in the new Jim Crow about how the carceral system structures economic inequality kind of in the labor market. And so what I'm kind of interested is in something that's sort of a hybrid in between those two things, right? How racialized mass incarceration, on the one hand, shapes work outside of prison and jail, but it does that through carceral coercion, right? Rather than exclusion, right? So it's not that people are always being locked out of work, it's that sometimes they're being pushed very violently into work, but in a highly subordinated way. And so, part of what's at stake in that, and part of what you see in the prison labor jurisprudence is, a lot of pressure on the boundary between what you kind of locate in the carceral state and in punishment and in prison and what you consider outside of it. Because the prison labor doctrine puts all of this weight on the idea that you're kind of outside the regular economy, you're inside the prison. But then there's all of these boundary cases that turn out to be super problematic. Like, how do you think about someone who's on furlough? How do you think about someone who's still serving a term of incarceration, but they're on work release outside the prison? How do you think about halfway houses? How do you think about parole? How do you think about reentry? And so it turns out that it's actually quite difficult to draw a clear line, right, between these systems. And on the one hand, that's super dangerous and scary, because what it means is all of these doctrines that have been developed and justified by the kind of prison side of it, right, where it's like, this is a special separate thing, and therefore there's going to be all of these exclusionary practices of the sort that Andrea was just talking about. If it turns out that you can't really isolate that and show that there's a sharp line between the prison and other stuff, then you see this risk, which I think you do in fact see, of kind of all of these doctrines to exclude and subordinate workers in prison kind of metastasizing and traveling kind of further and further outside of the prison. And I think that's what you see in a lot of the things that I've been studying, right? So you have a prison labor, you have a prison labor precedent, which then gets mobilized to talk about work release, which then gets mobilized to talk about conditions of parole, which then gets mobilized to talk about community service as part of a diversion program and so forth. On the other hand, there's a kind of radical potential there, right, which is to question the freeness, right, of kind of regular labor. So the other way to run that argument, right, is to say that the conditions of coercion that are so obvious when you talk about the prison aren't unique to the prison, and in fact shape the work that a lot of people are doing every day, either in their own lives or in the person they're working with side by side. And so that, I think, is kind of the upside and exciting part. It has something to do with kind of the politics of organizing around this. So it's a challenge to the traditional labor movement strategy with regard to prison labor, because that strategy historically has relied on the idea of separation. Right? So what we want to do is we want to protect free labor from downward pressure from prison labor. And we don't necessarily do that by abolishing the carceral system, and we don't necessarily do that even by abolishing prison labor, but we try to segment it off so that it's non-competing. So you have what's known as state use, right, or prison labor, which is supposed to be just in the state, not competing with the private market. Or you'll limit prison labor to industries where there isn't a domestic analog. So prison labor might compete with overseas labor, but it wouldn't compete with labor domestically. And then it's okay to exploit the heck out of it, right? And so, you know, that kind of move, which sometimes supports incarcerated workers' rights in situations where you can see direct competition on the rationale of protecting free labor, it does that from a stance of antagonism and separation. And that antagonism and separation is shored up by the kind of hierarchy of deservingness between the kind of model worker, law-abiding citizen kind of frame, and someone who's serving a criminal sentence with all of the racial stigma that's associated with that. You know, both in some cases, regardless of how someone would be their descriptive phrase. So on the other hand, when people are being forced to work at McDonald's or being forced to work at a day labor agency, in a situation where they haven't actually even been marked as being convicted because they're not incarcerated, they haven't necessarily been convicted, that separation between free labor and people impacted by the criminal legal system starts to break down. And you know, again, it's scary because those tentacles can reach really far and wide, right? Tens of millions of people who are part of these systems of child support debt, of fines and fees, of parole, money many times larger than the number of people who are serving a sentence of incarceration at any one point. Not that that isn't very large and very bad. You know, in Los Angeles, where I've studied some of this, there's 100,000 people a year who go through the court-ordered community service system, right? Just in Los Angeles, just each year. But then again, there is also this potential to make deep connections between the labor movement and movements against racialized mass incarceration. If people in the labor movement can come to see the carceral state, not as just like this other thing that's about punishment, but as a source of power over workers, including workers in the private sector. And then I think the kind of complementary point is there's also a kind of challenge, but also opportunity for people who are kind of focused on movement in the kind of carceral space, or people who are doing anti-carceral work, either in terms of reducing incarceration and decarceration, or in terms of reentry. But those efforts often turn to work, right, as the centerpiece of the alternative, right? So work becomes central to alternative sentencing. Work becomes central to reentry. But because the point of the work in the sort of narrow anti-carceral frame is to be something that's better than jail, right? And that becomes this very low bar that you're supposed to be clearing, and if you do, you celebrate it. It's not always understood and analyzed as creating new forms of work and regulating it in ways that create extreme levels of vulnerability. So it's not really thought of as, oh, I'm doing labor policy now, right? When I talk about court-ordered community service, that's not the point. That's not the dominant frame. And so like community service is often offered as this benevolent alternative to incarcerating people for non-payment of fines and fees. And it's terrible to incarcerate for people for fines and fees, but it's a little strange to think that creating a system of involuntary servitude is like this great liberation, right? Even if, you know, in complicated ways, it might not always be as bad. People are focusing on a way to get people out or keep people out, not thinking about, oh, I'm creating and advocating for a form of highly vulnerable unpaid work. And in fact, you've seen community service being offered as like the progressive thing that people should do to get rid of debtors' prisons. So the implicit background, though, of that move, if you think about it in the court debt contest, for instance, the implicit background is like, well, the reason why you're creating these community service positions is that people don't have jobs. Right? If people had jobs that paid a wage that would allow them to pay off their debt, you wouldn't have to create this whole other system below the floor of labor and employment rights for a specifically racialized and targeted population. So the move then would be to say, okay, so instead of thinking about community service, like why wouldn't it make sense for an anti-carceral movement to be saying, look, we need a jobs guarantee in order to do good criminal justice policy, right? Like that would be a moment where you could link demands for economic justice that aren't always thought about in a criminal justice frame to the concerns, right, of people who are facing incarceration. So basically, those are the kind of two moves that I'm interested in doing, like getting the crim people to think about what they're doing as doing labor and social policy, and getting the labor and social policy people to think about what they're doing as being fundamentally invested in the carceral state that produces an impetus to join in kind of abolitionist work.
Excellent, thank you. And RJ, let me turn finally back to you. And it strikes me that a lot of the comments you made really resonate with what Noah is just saying now. When you talk about campaigns for decriminalizing sex work, you immediately link them to the labor struggles and protecting human rights of a range of other workers. So maybe if before we turn to a few audience questions, tell us a little bit about what this sort of demand for intersectional thinking and organizing kind of means in your work.
Sure, thank you. And thank you, Andrea and Noah, for just an amazing presentation to get us all really thinking about some higher level intersectional work. I know it's going to impact my work, and I'm going to be sharing it with our organization. So, you know, some of the specific things that we work on besides trying to just decriminalize, because for us, decriminalization is a first step, not a last step, in the sectors of the sex trades that are criminalized. You know, we sort of have no models in this country, and one or two in the world, of effective worker rights protections and labor regulation in a decriminalized sex work context. So for us, that is a first step. We're sort of a baby movement in that way. There's much more that needs to happen beyond that. But we also work to protect the human rights of workers in the legal sectors of the sex trade. So those are often forgotten about, very often, because decrim sort of takes the spotlight around sex work, and because people don't even understand the concept of sex work as this very broad umbrella term that includes so many different labor sectors and industries, some of which are legal, fully legal in the United States, including ones I've worked in, including go-go dancing, stripping, certain types of massage, and of course, porn, the big one, the adult film industry. It's always struck me as so strange, hypocritical, and ironic that the work I've done that is out on the internet forevermore, in public view, that is fully sexual work, is legal, taxed, everything regulated, and that work we do as escorts or full service workers behind closed doors in private is criminal. It makes absolutely no policy sense unless you really start to dig into the capitalist reasons for why that is, and the market rate. And even courts have rejected, when you dig into the jurisprudence, the argument that if one is legal, the other one should be. In fact, those arguments have backfired on us, and the morality police just say, well, you want to make porn illegal, you know? So we're not pursuing right now, the movement isn't really pursuing remedies in the courts or impact litigation so much as this state-by-state legislative strategy to decriminalize what is currently criminal. But in terms of the legal sectors, wage theft is rampant, sexual harassment is rampant, and really rampant, because of course people assume sex workers can't be sexually harassed, which of course is not true, or sexually assaulted for that matter, whether it be by police, managers, customers, or anyone else. And then racial discrimination and racial hierarchies, white supremacist hiring practices are rampant as well, in both, specifically in the labor sectors that are legal, strip clubs, the porn industry. We are thinking about a research project right now with a partner organization that could lead to impact litigation in the future around white supremacist wage disparity in the adult entertainment industry, which is, there's now a shout out to our colleagues at the BIPOC Adult Industry Collective, which is doing a brand new organization, a year old, doing tremendous work to support BIPOC workers in those legal sectors, particularly in porn. And not to mention, undoing racial archetypes and things that are really perpetuated in the industry without going to a sex negative place, which is often the sort of knee-jerk reaction, right? Because we believe in sexual liberation and an end to white supremacy, and that those things must go hand in hand. So those are some of the issues we work on, in addition to right now in New York, we are pursuing, many years ago, my organization introduced one of the first vacature bills. So for those who don't know, vacature is a word that some states use that is similar, but has some differences to expunging a criminal record, but basically clearing the slate of your criminal record if you have crimes on your record, convictions that were a cause of that were connected to your trafficking experience. You were forced or coerced to commit a crime by your trafficker or because of your trafficking experience. So right now in New York, those vacatable convictions are only prostitution related, and we have a bill that we're hoping passes this session to expand vacature so that all criminal convictions can be vacatable if somebody has had a trafficking experience. And we hope that those can become automatic as well once that's implemented. Some states have a more expansive law than New York does at this point, including some very conservative states. So we're trying to get New York on board with that. And then we had a recent victory I can share in New York when what we call the walking while trans ban was repealed. This was to repeal loitering for the purposes of prostitution in New York, which is one of about 8 penal codes that people are arrested for doing sex work. But this particular prostitution related law was used as a profiling law. So for many, many years, it's been used to profile as a racial profiling, gender profiling, and even profiling people's body types and clothing. So trans women of color, in particular Black trans women, and some cisgender women as well, have been targeted for years using this law because they were showing too much cleavage, or their skirt was too short, or simply they were standing in a particular stroll that's known for sex work, and generally just being profiled as sex workers, as trans people, as Black folks, or all of the above. So, one demographic of folks that we do work with are people who are actually profiled as sex workers, but are not doing sex work. We serve trafficking survivors, sex workers, and those profiled as sex workers, and these all have these intersections. So walking while trans was repealed. That was a great victory that we just had a couple months ago, and we're looking at similar profiling type sex work related laws in other states as well. I mentioned briefly Louisiana has had the first ever decrim bill introduced as well, which we don't know what will happen with it. We're hopeful, but as Andrea knows, it will be an uphill battle here, a long-term struggle most likely, but it's historic. Just the fact to me that a bill such as that is introduced in the Deep South. And so, the last thing I'll say is, among all of those other things, we do reporting and human rights documentation on the problems of coercive services for trafficking survivors and sex workers who go through these so-called problem-solving or alternative courts, like the HTIC, the Human Trafficking Intervention Court in New York. On our website, we partner with Yale on a report, one that is New York specific and one that is nationwide, that shows, based on our experience, that social services are not effective and actually traumatizing and unhelpful in many circumstances when they are tethered to the courts, even these so-called alternative courts, and that service provision is only useful or necessary when you meet folks where they are, when they are trauma-informed and harm reductive, and when people actually want them, right, from their own agency and autonomy. So these services that are coerced are put upon people, just like fees and fines, just like the traditional criminal courts that impose conditions that people either don't want to or can't meet, that keep them tethered to the system. So too do these coercive services keep people tethered to the court systems in the context of people who have already been highly traumatized and just continue to be further traumatized by the state. So those are some of the ways, some of the issues that we are working on across the intersections of racial justice and worker rights.
Amazing, thank you. So let me quickly check in with Megan.
Sorry, I have to pop up because this panel is so interesting and so cool, and I don't want it to end, but we have just a few minutes left. So I thought maybe you all could each share your thoughts on a question that I can lift up from the chat, which is that a lot of the issues that you've talked about today, you've mentioned abolition, you've mentioned decrim, you've mentioned just like a lot of like really fascinating work that's also often invisible because it's not front and center in the labor movement. Do you have any advice for people, you know, some quick advice on how to effectively educate and persuade lay people on issues that are controversial and stigmatized when they should not be?
I mean, I will say, and I started talking about how I first came to this topic, right? And that's because I was in Angola talking to somebody. And I think that the best way, and Brian Stevenson has talked about this in terms of proximity. It is difficult to make these arguments if there's not a person in your life who understands what this perspective is and what that impact is. And so the first thing I would say is everybody should get more proximate, right? And there's lots of different ways that you can do that. We here in Louisiana have an amazing set of organizations, including Voice of the Experience, Operation Restoration, and many others that are led by people who are directly impacted by incarceration. And so I would think about, and they have open member meetings, right? And these organizations exist across the country. And so I would encourage everybody to not only go and listen to the folks who are directly impacted, but bring a friend, bring your grandmother, right? You know, I mean, I think as we exit COVID pandemic, that there's going to be a lot of ways in which we can renew connections that maybe we've had to kind of do more distantly in the last year.
I could not agree more with Professor Armstrong. You know, in our context, in the sex worker rights movement, if you ask people, most people, it's just very theoretical to them. They feel they don't know anyone who's a sex worker or who's ever been a sex worker. And that's often not true, right? The stigma is so deep and so pervasive, it's very difficult for people to be out. Both internalized stigma as well as external stigma. So many reasons for people not to be out as a sex worker. Whether it's, you know, even the legal sectors have great stigma. So, you know, I have the great privilege, partly my own choice, but also privilege to choose to be out. It is an active choice. I do have consequences for that. But I think the more of us who do come out, sort of analogous to the LGBT movement, it personalizes and humanizes and contextualizes something that is otherwise theoretical to folks. I think it's also been effective for me when talking to folks, you know, if I'm able to have a real honest conversation with someone about how they consume our labor as sex workers, how many, if not most people, have or do consume the labor of sex workers, whether that is some type of pornography, or, you know, going to a strip club with your friends, you know, even if you've never hired an escort, you have probably consumed the labor of people in the sex trades at some point in your life. And yet the workers who produce that labor are seen as, you know, completely disposable, sometimes inhuman, and just really objectified in the extreme. So I think that knowing people, I think that, you know, even hearing an interview or a panel where someone says, you know, I'm Muslim and I'm a sex worker, or I'm a lawyer and I'm a sex worker, whatever it is, it shows that we are people, you know, we're people with families. There's tons of parents in the sex trades who choose to do sex work because it makes them able to financially and time-wise be more available for their family. There's so many narratives that no one of our experiences can encapsulate. That I think, you know, just want to second that in any issue, knowing people is humanizing. And I think also it sounds very, very basic, but the general premise of the human rights framework that all beings are inherently equal in dignity and rights, no matter who you are or what you do, is very basic and very radical at the same time in this.
I completely agree with all of that. And just to sort of make a complementary point, I mean, I also think this sort of builds off RJ's point about the ways in which people are implicated, including in ways they don't necessarily know. I also think that that's an important strategy. People who didn't know that their desk in their state university was made by incarcerated people, right? Or people who didn't know that that call center was staffed by incarcerated people. Every year in California, there's an article about all of the incarcerated workers fighting wildfires and so forth. And that and the kind of follow the money kind of strategies, I think in the labor movement in particular, like those could be very important in terms of what the questioner asked, like finding ways in which the working conditions are connected in ways that aren't necessarily obvious. And as Andrea said earlier, often deliberately not obvious, but there are connections to be traced in a variety of ways.
Okay, well, thank you all so much. I wish this panel could keep going because you all are so fascinating and I could listen to you talk for hours and be in conversation with each other. But yeah, we're a little past time. So just on behalf of the entire managing board for OSLJ, thank you so much for being here. Thank you, Professor Cohen, for moderating. Your time and energy, they're privileges that you afford to us, and especially heightened privileges given everything that goes on with the pandemic and we don't know the contours of your lives. So just thank you so much for being willing to share your time and energy with us today. And thank you, Professor Cohen, who is, for people who don't know, all the way in Australia and is dealing with the time zone difference, but still very graciously decided to moderate. But yeah, thank you.
Thank you.
Thank you all, and thanks, Megan.
Yeah, you can hop off whenever you want.